Hi, today's topic's going to be not so much substantive as personal. I'm going to be talking about writing a column on family law issues. It's something which I've done for many years now and continue to do, and there's going to be a change coming up. So I'm going to discuss a little bit in terms of my concept, what I try to accomplish in writing a column, and then where I'm going with that in the future, and ask for some assistance and help from my viewers and listeners on this. I started writing the column many years ago at the request of a mentor of mine, a terrific family law attorney named Jim Podell, who was both an adversary and somebody who taught me a great deal about this. And at the time, he was the editor of the Wisconsin Journal of Family Law. And he asked me if I would write a quarterly column. And as it turned out, it was a lot of fun to do. I could express my opinions. People actually read it. I've been quoted several times by the Court of Appeals based upon columns that I wrote. And I began to realize that I enjoyed expressing my opinions in this area of law. And so I transitioned from the Wisconsin Journal of Family Law to the Wisconsin Law Journal, mostly because they had a terrific editor who I loved working with. And I wrote a fairly regular column for them for many, many years until a couple of years ago when I switched to the State Bar of Wisconsin and their Inside Track monthly newsletter. I'm going to be switching back to the Wisconsin Law Journal, and let me just explain for a minute why, and then talk a little bit about where I'm hoping that this goes. The problem with the Wisconsin State Bar Inside Track, which is a great publication, is since the Wisconsin State Bar has mandatory membership, every lawyer who wants to practice in the state has to be a member. So in writing a column critiquing a given case or taking a side on an issue in a certain case, I am more likely than not going to be offending somebody who is a member of the State Bar of Wisconsin. That I can live with. They're not thrilled with it. But moreover, my columns, not infrequently, tend to express my never to be humble opinions regarding what some court rulings were about. And especially if it's a case that is currently on appeal, such as the grandparent visitation case that's going to be argued next month before the Supreme Court. I'd like the court to know what I'm thinking. Don't know if they're interested or not, but at least one time back in the day when I wrote for the Wisconsin Law Journal, it was a lot of fun to listen to oral arguments in a case and have one of the justices ask a lawyer, well, let me read you something from a column on this issue which appeared last week in the Wisconsin Law Journal, and then read from my column and questioning the lawyer. And that's a great thrill to do that. Well, the Wisconsin Bar isn't thrilled with that because they have to work with the courts and they don't like it when I tell a court what to do. It's also, of course, taking a position against one of the lawyers who's a member of their organization. So essentially the articles have to be toned down and diluted. And in fact, over the 2 or 3 years that I've been writing for them, they have rejected several of my articles because they're too partisan. And I appreciate where they're coming from. It makes sense. They're an organization that, in one sense or another, represents all 22,000 lawyers in the state of Wisconsin. Yeah, there are really that many. And they don't want to be irritating and angering anyone, especially when it's a mandatory bar association and the person that I'm irritating or anger cannot essentially vote with their feet by leaving. So after some consideration and having another column rejected because I got a little harsh on a decision, I went back to the Wisconsin Law Journal, and their feeling in terms of my articles being opinionated, how's that for a term, was, oh my God, yes, the more the better. Essentially, they took the exact opposite attitude. They're looking for articles that are provocative, and the last thing they want is something that's pure vanilla. They're looking for Rocky Road. Unlike the State Bar that's providing information, the Wisconsin Law Journal is trying to sell subscriptions, and the more provocative an article is, I'm going to use the term provocative rather than interesting, but I guess they go, to me, at least they go together. To them, the more provocative, the better. So they've given me license, and I want to be careful how I use it, but there are certain things that I feel very strongly about, and particularly, like all good family law attorneys, I feel very strongly about protecting children. So I chaired the Guardian ad litem committee for like 9 years for the State Bar of Wisconsin, and I've written a lot in terms of what I think is best for children and what helps protect children. As anybody knows me, realizes or read any of my columns, I like anything that's designed to lead people towards settlement and towards resolution of cases, and I don't want to be restricted or have my hands tied. The grandparent visitation case being the best example, I feel very strongly that while the grandparents raise some interesting issues, that grandparents provide a great benefit to grandchildren. Hey, I'm a grandfather myself, hard to believe a young guy like me, huh? But I am, and there's no greater pleasure, but affording visitation harms children. And I want to say that. And I want the court to know that. I don't know if they read it or not, but if they do, I think somebody should be speaking up from the outside and not just doing namby-pamby in terms of, well, here's the case, here's the issue, and do what you think right, but A, giving an opinion as to what they ought to do from an independent point of view, and then B, if I don't like the opinion, being real direct and no questions asked about what's wrong with it and why I don't like it. I'll do it in a respectful way. I'm not out to irritate any courts or get any court angry with me, but I do want to express opinions, and I want to be free to be able to do so. So with great reluctance, I'm terminating my relationship with the State Bar of Wisconsin and not renewing for next year my articles for Inside Track, but instead we'll be writing for the Wisconsin Law Journal. I've already submitted my first article. Guess what? It's on the grandparent visitation case. Guess what? I gave an opinion and told the Supreme Court what I think, and was very clear and distinct about it. There's always a danger, and I've been asked, if you write an article and express an opinion, what are the odds that, or the risks, that some lawyer on the other side of a case could cite it against me? Well, it could happen. I've only had it happen once. For the most part, when I write and express an opinion, it's about an issue that I believe in strong enough that I would not take a position for a client contrary to that position. So if I think a client is doing something that harms children, I'm not going to go to court and advocate for it. I don't care how much that client's willing to pay me. I'm just not going to do it, and I'll turn that client down or refuse to argue that position. By the way, the only time it happened to a case, I don't think I actually did it, but I was thinking of quoting the old Abraham Lincoln story where he argues a case in court in the morning, taking a certain viewpoint, and convinced the judge. Back in court, same judge, same issue, on the opposite side in the afternoon. And the story is he argues it even more brilliantly than he did in the morning, and the judge says, Mr. Lincoln, I'm very convinced by your argument, but it's the contrary of what you argued this morning. And according to legend, Lincoln's response was, but Your Honor, this morning I was mistaken. Whether that story is true or not, it's a great example of how lawyers can argue out of both sides of their mouths at the same time. Not that I'm anywhere near as brilliant as Abraham Lincoln, God knows, but the point being, my answer is if I try not to let opinions I express run contrary to positions I'm taking in court, but if they do, B, I'm in the best position to distinguish the earlier opinion and explain why I was mistaken this morning and correct this afternoon in front of the judge. So all that being said, I'm going to partner with the Wisconsin Law Journal. They've agreed that to run the articles and assign a new editor to me so that we can try to provide information that I hope is at once informative, entertaining, and provocative. I ask for two things here. A, if you read an article and you disagree, let me know. Tell me what you think. Be interesting to get some dialogue started, and interesting enough, I'll write a follow-up article and comment again on any criticism, and I welcome it as long as it's polite and professional. And second, if you have any ideas for any articles, something that would be interesting, something that family law attorneys might be interested in hearing an opinion about, or even informational about, drop me an email, gherman@loebherman.com, and I would be pleased to take a look at it, and if I'm interested, write an article about it in a future upcoming issue.